So we have a fee simple estate, which is A to B. We have a life estate, which is A to B for the life of B. And if B owns the property as a life estate, they can only possess it, use it, and then have it ready for someone else. That's important. Let's say you say from A to B for the life of B, then to C. Then B does something bad with the property. Now what does C get? Not what they should have got, right? They get less of an estate than they should have got. So then there's a potential action by C against B for not taking care of the property. So if you've got a life estate, your job is to take care of the property for someone else. Now, these are called non-possessory interests. So far, with the fee simple and the life estate, we've been talking about situations that involve possessory interest, your right to possess the land and do with it what you want to while it's yours. But these are rights that you can have to someone else's property that don't include possessing the property. And where does it start talking about things like easements and profits in your chapter? What page are we on? Non-possessory interest. While we're looking up the page number. 693, 694, good. So, has anybody heard of an easement before? Yeah, what kind of easement have you heard of?
Well, my parents own property on a lake, and
right.
The house behind has an easement on their property.
Right.
And then they also have an easement on the other people's property too.
Yeah, so you can have reciprocal easements. Like, yeah, you can come across mine to use the lake, but if I need to go this way, then I want an easement across your property. A big easement, right? You know, you ever seen that where there's a house for sale on a lake and it says lake access? Mm-hmm. Right? That often involves an easement across someone else's property to get to the lake. In fact, when I did a lot of real estate law practice, that was one of my most common types of cases was lakefront disputes. Talk about nasty disputes. No offense to people from the Chicago area, but people from Chicago would come over and buy up a lot of land, and then they'd get out all set up on the lake, and now here comes the neighborhood across their yard with a canoe or something. They're calling police, and then, you know, it's a huge issue. And why? Because they never bothered to check to see who had a right to come across their land. There were parks on their lands, there were beaches on their land, there were, you know, accesses down to the lake that they didn't know about, and they were mad. Right? So that's one type of an easement, access to the lakefront. What other kind of easement have you heard of?
I have an alley on my property.
Okay, so somehow somebody needs to get through some way, and so maybe a portion of your property is allocated to a road or an alley that goes through there. Anything else? Yeah.
The county has all different easements.
Yep.
Drains, you know, like power lines.
Right. Yeah. Did I tell you the swimming pool story about my easement? Yeah, so I had to move my swimming pool because the county called me. They're like, oh, there's a big drain easement on your back property line. I'm like, yeah, but you never used it. And they said, yeah, we don't care. So, but we planned it, so someday we might use it. Okay, I don't see how that's possible, but okay. What about like cable or power or anything coming into your property? You know? Right. So yeah, you know, it's on someone's property usually, and so they have a right to come on it. So an easement is the right to go on someone else's land and use it, but not possess it and not use it for something different than what the easement is for. So why is this important to you? Not only check the deed when you get it to make sure you got everything you're entitled to, but make sure there aren't any restrictions on how you use the property, that there isn't some easement that you don't know about. Now, a lot of times in a deed, it'll say easements of record. Well, then you got to go look in the record and find out what type of easements there are. Right. So, did I tell you a story about the cable company digging up my yard? So, when I lived in Kalamazoo, the cable company came into our neighborhood with a backhoe. Now, you know this is going to be a problem, right? You know those machines that lay a nice little slit in your yard and bury the cable nice and neat? They didn't have one of those. They had a backhoe. So I'm like, whoever's yard they're going to, I bet that guy's not going to be happy, right? So I go to work, I come home, it's me, right? So my whole front yard is tore up. And they left the hole. Like they just drove all over my front yard, they tore it up, and then they left the hole there. So I called Charter Cable, and I said, you know, your people came into my yard and they just tore up my front yard. And their response to me was, sir, you don't understand easements. And I said, maybe I do, try me. And they said, we have a right to come on your land and, you know, remove things to put the cable in or repair it or install it. And I says, you know what, you're right. However, that's limited to this many feet of my front yard. You tore up my whole front yard. And besides, you have the ability to come in and dig a hole on it to, if it relates to the cable, but when you're done, fill in the hole. And they said, oh, you're right, but that was somebody else. We subcontracted that work. Well, what do you guys know about when you delegate a duty under a contract to someone else? You are still responsible. So I said, yeah, I don't care who you hired to dig the hole. They need to come back here and fill in the hole and fix my front yard. And they said, you're right. We're sorry about that. We'll get it fixed. So I hung up the phone, and I knew where they were at. So I drove over there, you know, and as I approached, they said, yeah, he's standing right here. So I took him back to my yard, and they ended up giving me a new yard, which is great because it wasn't a new yard to start with. But anyway, I mean, the moral of that story is if you have a right to go on someone else's land and use it, you have to use it for only that purpose, and you need to leave it in good shape. You can't come and camp there if that's not the easement. We had another easement beside our property, which made our property pretty wide. It was all the sewer and everything that comes onto our property. And people would walk back and forwards, you know, on property. It wasn't for that purpose. It was for the drain. So I shot them a few times. They quit coming on the land. I'm just kidding. All right. A profit. A profit is a little bit different. It is the right to go onto someone's land and take something from it. So you could potentially dig a hole if that's what you're entitled to do. You could drill a well. You could take, you know, over where I live, gravel pits are fairly common, right? You go in, you dig it up, and then you fill it with water and charge people as if it's lakefront property, but that's a whole other story, right? So a profit involves actually going onto the land and taking something, harvesting trees, crops, oil, those type of things. And then finally at the bottom there it talks about the fact that if you grant an easement to somebody to your land, when you sell your land, the easement goes with it. Right? So that's the flip side of when you buy land, make sure that you know what easements are on it. If you sell your land, the next person who buys your land gets that easement. You know, the property is subject to that, or whatever easement they had goes with it. Yeah?
What has to be done to, like, if you wanted to give an easement to somebody, what has to be done to make that?
There are different ways that you can have an easement. Often by deed, you could have the easement, or often there's some type of agreement that you put in writing and you record it so that people know that there's that. So, you know, for every utility easement, there's some type of writing in the record that shows what that is, and then it's recorded as part of that plat that those easements are there.
Once it's on there, is it always on there?
Well, more or less. It continues unless, you know, there are some ways that it can go away if it's never used. So we'll talk about that in a minute. Here are some other ways it could be created. So you asked the question, how can you create an easement? A common way is by agreement. It might be in the deed itself. It might be, you know, upon my death I grant this easement, so it's actually in a will. It might be a contract between the parties. Here's an interesting one, by implication. Anybody ever seen land that started as a farm, it gets divvied up, people buy it, right? Well, the road's in one place. So there's the possibility that you've now landlocked some of the property because they can't get to the road. well, then the law might imply that there's an easement, that there's a right to go over some of the property to get out to the road. Otherwise, somebody buys a property, they got no way to get out there. It might be by necessity. This is an interesting one. By adverse possession. I think I mentioned that a little bit last time. But the idea that if you travel on someone else's land long enough, you might get an easement over that land. Right? Or, like one of the common ones I've seen are these common driveway easements. You ever seen them like in the city where it's not a lot of space between houses, and you kind of wonder how that driveway got there? Well, in a lot of cases, parties agree that, well, you can be on my property, I can be on yours for the purpose of having a driveway. Well, in some cases, they just start parking there or driving through there or whatever, and then the law says, well, the parties have created an easement by adverse possession. Now it is an easement that they both have to the driveway. So how could you terminate it? That was the question. Well, you could actually deed the property back to whoever deeded it away. So remember that landlocked example? Like you parcel out your property, you buy it back, you don't need permission from yourself to go across your property. So it could go away that way. Or perhaps it's even abandoned. This is pretty common, that you subdivide or you create parks or beaches or whatever, but then it never gets used for that purpose. I've known of cases where people build gardens and then later they find out that's where the boat launch was planned to be. But many years later, they bring an action to say that easement was never used, it's abandoned. All right, a license. You guys, most of you have a license, right? Probably how you got here today, a lot of you. This type of license has to do with the right to go on someone else's land, except it's a little different. You guys hear that buzzing, or is it just... to go on to someone else's land, but it's a temporary thing that can be easily revoked. Do you remember that speech when you first drove and your parents told you that driving was a right, not a privilege, right? Or something, or privilege, not a right? Yeah, privilege, not a right. Same thing with a license. You could get it, but then the owner could take it away. Right? Like I do this at the movie theater. Like I'm going in and the person says, tickets please, and I say, oh, you mean my revocable right to enter onto your real property? I don't know, they don't think it's that funny, but that's basically the idea. That's a license. That's a printed document that tells you that you have a right to go onto their property for these purposes, and if you don't abide by these purposes, they can kick you out, right? That's a license to go on someone else's property. What other kind of licenses do you know about? Right? So you have certain rights to use the lift, to use the, for those type of, what did you say?
Dealer license.
A dealer license. Okay. What about related to property? Camping. Yes, camping's a common one. How about deer hunting? A license to go onto someone else's property to use it for that. And in the theater, if you don't abide by their terms, they could revoke the license. So can I help you, sir?
No.
Okay, good. We're teaching. We're having class. Like the most common one for me at the movie theater, the screen comes up and it says, take noisy children to the lobby. I keep taking kids out and they get mad at me. Anyway, so it's a personal privilege. It goes to an individual person. It can be revoked. So how can you transfer ownership interest in property? You can have a deed. And we'll talk more specifically about the different types of deeds. You could gift it to somebody. Does this sound familiar? It's a little about how we talked about conveying personal property last time. You can get it through a sale. You could inherit it from someone else. Adverse possession or eminent domain. Does anybody remember that one? That's like all the way the beginning of the chapter. We talked about constitutional rights. Eminent domain is the power of the government to take private property for a public purpose with just compensation, right? Anybody live out by M6? Oh, I'm from Hastings, and when I was younger, to get to Hastings, we had to ride horse. No, we didn't ride horse, but there was no M6, right? If you were on the other side of Grand Rapids, you had to loop all the way around the north side of Grand Rapids to come down and go to Hastings. And there was a bunch of farmers' fields there. Now there's a highway through there. So how did they do that? How did they go across all that private property and build a highway on it? Right, they say, we're coming through, here's our plan, and you can have a hearing, and you can object to it if you want, but we're coming through, and we'll give you something for your property, and we say it's just compensation, and then maybe there's a dispute over whether it's just compensation or not. So you often hear of that going on. So deeds. A deed is a written document to transfer an interest in real property. It has to list the name of the grantor or the grantee. It has to show some intent to convey. It's enough to say from A to B. I, A, want all my stuff, all my biggest bundle of rights that I have to go to B. A legally sufficient description of the land. Anybody ever take off in a plane and you look down and you see a bunch of squares on the ground? Maybe it's just me, but yeah, I mean, there's a whole grid system throughout the United States that lays out every parcel of land, right? So when you put a description in a deed, it usually refers to a township or a range or this part. In fact, over in Lansing, there's Meridian Mall. Meridian relates to the Meridian line, and there's the whole country is mapped out, and your property is described in reference. It's not over to that rock, left to that tree. It's, you use actual distances and measurements. The grantor signature, the one making the grant, they have to sign it. And then the actual delivery. Does this sound familiar? You have to have this element. It's not enough to intend it, to think it, to write it up and shove it in a drawer. You actually have to convey, you have to deliver the deed to the other party before you have a conveyance of real property through a deed. All right, so some of these deeds, fairly complicated, kind of expensive to draft up. Some of these deeds are done dirt cheap. For example, warranty deed. No one? Okay. Warranty deed. A warranty deed is good. It warrants that you have good title to the property, and everybody before you did too. So when you convey property to somebody with a warranty deed, you're saying you're getting good title, and if you don't, I warrant, I'll fix it. Right? That's what title insurance is about, right? So you get someone else to look at title and make sure it's okay and to insure it, right? And there's other types of deeds they talk about, a special warranty deed and an implied warranty in a new home. Here's the trick. You're going to see this very soon, maybe even a couple times, right? A special warranty deed sounds better, doesn't it? Special. It's not. A special warranty deed only warrants that you, the grantor, have good title. It's like saying, I warrant that I have good title, but I don't know about all those folks who had it before me, right? So which do you want? Do you want a warranty deed or a special warranty deed? You want a warranty deed, right? And then there's this implied warranty. You remember the implied warranty of merchantability in goods? It's kind of the same thing with homes. You don't just build a new home, sell it to somebody, and say, well, tough luck, it wasn't quality. In some states, there are statutes that imply a warranty when you sell a new home. A quitclaim deed. A quitclaim deed, not so good. A quitclaim deed conveys whatever interest you have in the property to someone else, which might be nothing. So if I say, I grant to you whatever interest I have in this building, what is that? Yeah, I'll give you a hint. It's called Cook Hall. It's not me. Yeah.
Isn't that a good way to transfer property? Like,
it might be.
Like,
so,
can I give you a situation? Like, say,
you can give me a fictional, not real example, yes.
Someone wants to give you their house, like just give it to you. Can you do a quitclaim deed? And
Well,
would that be sufficient enough to?
Well, let me put it this way. A quitclaim deed contains no warranties. A quitclaim deed says, here's my property, I'll give it to you, or I'll sell it to you but for $1 or whatever, but I don't warrant that I have good title to give to you. Versus a warranty deed that says, here, this property is yours, and I warrant that you have good title, and if there's any problems, I'll fix it. Which one do you want? You want a warranty, right?
Do you get title insurance? Does it matter?
Well, you won't get title insurance with a quitclaim deed,
Oh,
right?
You can't.
You're going to want title insurance with a warranty deed. You know, if somebody says, here, you're going to get a quitclaim deed, that means you're getting whatever I have, which could be nothing. Right? It's not. There are no warranties with it. Okay?
Who does the deed?
Yeah. So it's kind of a strange question, but yeah, that's what people ask. They're like, okay, you've convinced me. Why would I want this versus that? Why are we even talking about this? Let's say I own some property and I'm getting married, right? You can also talk about this at the other end, but and I own it solely in my name, and I want to convey it to my wife. I don't need. So what do? I convey it to myself and my wife. I don't need to warrant to myself that I have good title, right? So in those limited cases, a quick, less expensive, expedient way to do it without doing, a title search and everything else is to say, I convey from myself and my wife, from myself to myself and my wife, for no consideration, no warranties. Now we both own it. So we both own it subject to any liens or anything that are on the property.
You can't do it to your kid, though, can you?
Well, you could. I mean, again, you could do any of these things. I'm just saying, if you are thinking about getting property from someone, the most appropriate way to get it is with all warranties. Okay? And then these last ones, a grant deed or a sheriff's deed. In some situations, there might be property available to you to get title to that you get through some kind of sale, right? So there's tax sales, or there might be foreclosures or something like that. So you could get a deed that way, not directly from the grantor, but through some kind of sale. One important thing to look at if you're going to do that is this period of redemption. Not everybody knows about this. If you buy property through some kind of foreclosure, a period of redemption is the period that the person who lost the property can come and get it back. So think about this. You now think you own the property, and within that statutory period, here shows up the person who lost the property with the money they owe, and they get the property back. So if you buy property this way, what do you want to do until this period of redemption runs out? Probably not a whole lot, right? Because if you improve the property or try to do something with the property, there's always the potential that the original owner could claim it back. So you want to watch that period of redemption. Then after that, you've got clear title to it. All right, I'm going to spend a lot of time on this, but one of the things you need to do besides give somebody a deed is if you're the grantee, if you're the one getting the deed, you want to ensure that it gets recorded in the public record. Now, why is it important that the public know you're the owner of the property?
So that nobody else.
Right, so you are the owner exclusive to anybody else, right? So you want people to know that they can't have a right or claim to the property, that it belongs to you. You become part of that chain title. This last bullet has to do with racing to get your deed recorded. We won't talk about that one, but there usually is a requirement to record a deed. All right, so wills, another way to get property. You could get will, if you have a will, when you die testate. If you die without a will, you die intestate. And one of the reasons you want to have a will is if you die without a will, then the state determines what happens to your property. So whatever the statute says, that's how your property gets distributed, which may not be the way you want it to be distributed. So your real and personal property gets determined, the distribution gets determined by statute. And then adverse possession. This is kind of a tough one. Remember the idea that you occupy someone else's land long enough, sometimes they call it squatters' rights, and then it becomes your property. And here are some of the elements. Here's an example. I had a client, I don't know if I mentioned this one to you, but I had a client who was going to sell his property. And he got a survey of his property done and discovered that his neighbor, who'd lived there for years, had been mowing a 15-foot strip of his property and had put a fence up on his property. And the whole time he was there, after this fence went up, he and his neighbor both thought the fence was the property line. Can you see this happening? Like, people are mowing up to a fence and taking care of it. They believe that's where the property is. The whole time, his neighbor has basically been occupying 15 feet of his property. So he comes to me and he says, what am I going to do? I need to sell my property, but now there's what they call an encroachment. There's someone else who's on my property, who's claiming they own part of my property. He was concerned about this, adverse possession. So what do you think I did? I was at the time. So he came to me. I know that's what I tell you. That would be one route, right? Just say, well, you go out there and you take that fence down, right? What I found out is his neighbor was a real hothead. This is in Cedar Springs, and they do all kinds of crazy things there. And so I'm like, that's probably not a good approach. So we wrote them a letter that said, I said, trying to make it not about my client, I have this really nice client who needs to sell his property and discovered that you have a fence on his property. And would it be okay if my client bought back his own property? Like, we understand you've been mowing it and maintaining it for all this period of time, and technically it's his, but he's willing to compensate you for that. I thought that was a pretty nice approach, much better than tearing down the fence. And we ended up in a lawsuit about it because the guy was a hothead and he said, no way, I own the property now, it's mine. He claimed he owned it through adverse possession. And so that lawsuit went on for a while, and then one day the neighbor shot at my client. Well, you had to know that was coming in Cedar Springs, but my client was apparently too close to his fence on a riding lawnmower, and so he just a warning shot. He wasn't trying to actually shoot him. Shot over his head just to say, hey, whoa, don't get too close to my fence. And the state police ended up out there, and they called me, and it was crazy. But anyway, that really happened, yes. It really did. It happens in Hastings all the time, too. So anyway, we went to court, and the problem turned out to be that the neighbor, had not occupied the land long enough to own it by adverse possession, and we won. And I also slipped into the judge the whole thing about him shooting at my client. That helped a lot, too. But basically, this is statutory. If there's a statute that says you actually exclusively occupy someone else's land long enough without their permission, then it could become yours.
Do you know how long that has to be?
It depends on the state, the statute, and the type of adverse possession. Yeah, I know. I just wanted to see what time it was. The clock is behind the screen. So, I actually had the situation come up. We have these woods behind our house, and we built there because the guy who owned the woods is not ever going to develop it, and so this was a great place to buy some property. And when we first moved in, it was really nasty. It was like barbed wire fence and trees and all kinds of brush and stuff. And we said to the guy, can we clear some of that off just so I have a nice lawn and so the kids don't get tangled up in the fence? And he said, yeah, no problem. Just don't cut down all my trees and then don't build anything on it. I thought that was fair, right? So I cleared it all out and I planted some grass and it looked like I had a nice big yard, and then I put a swing set on it, and then one day he come along. I kind of wouldn't even think about it all, and he comes along and he goes, yeah, you put a swing set on. We didn't really have any agreement about whether I could put a swing set on, but he said, I just have a concern that if you keep acting like this is your property, then one day you might claim that it is. And I said, well, actually, I kind of understand that. I understand what you're saying about that. And so I moved the kids' swing and the fence that I'd put up. But So I had.
Did you shoot that a video?
I didn't. Yes, that was a real story I was talking about myself. All right, and then eminent domain, I mentioned that. Through the Fifth Amendment, the government has the power to take private property for a public purpose with just compensation. And we mentioned how the whole idea of just compensation might differ whether you're the person who's the government's trying to take the land for or you're the government. But the other thing is whether it's really the government or public use. Like think in local government, sometimes the people who serve in local government have a vested interest in what happens with property within that governmental region, right? And how they might personally benefit if they take private property. Right? So that can be an issue. Is it really the government? And, you know, like I think in Kalamazoo we had this come up too, is they wanted to take this whole strip of businesses, just completely level them and build a path and a park. And that's what they did. And people were a little upset with that because they didn't feel like that was a good, effective public use of the property. And these business owners were not going to have their business anymore. All right, leaseholds. I'm not. You probably have some experience with the idea of leasing property, so I'm not going to go into all the laws related to leasehold estates. But basically, the idea is the lessor, the one who's leasing the land, gives a right to the lessee, the right to use property. Anybody ever seen? There was a movie a long time ago called Duplex. Anybody see that movie? In this movie, this couple has this like 2-story house, and the upstairs is rent out to an old lady who ends up scamming them. But I don't want to spoil the whole thing for you. And they, throughout the movie, are harassing this woman. Like they go into her apartment and start messing with the pipes and all types of things. And that's just bad law, right? Basically, the idea is if you rent space out to someone, it's their space to use. And you're not supposed to go in there unless you've agreed that you can go in there, or the law permits you to go in there for some reasons. It belongs to them to use exclusively during that period of time, right? And that is called the leasehold. Right? So it's contractual. You know, usually there's some types of written agreements in a leasehold situation. But here are the different types of tenancies that come out as a result of a leasehold. There's a trick here. I don't want you guys to fall for this. A periodic tenancy. Notice it says a periodic tenancy does not specify how long the lease lasts. You would think periodic tenancy would be for a period of time, right? But really, periodic tenancy just means periodically you pay rent. It doesn't mean that it's for a set period of time. If you look at it, actually it says a tenancy for years is created by express contract and is for a specific period of time. So don't get confused by that. If I say that there is a lease for a year period or something, you might see the word period and go, oh, periodic tenancy. No, it's a tenancy for years. All right, and then the last one is a tenancy at will. Maybe you don't have a written agreement about the term of time, but you're staying there and somebody's letting you stay there, and there can be a tenancy at will. I have this come up occasionally. I have somebody who lets someone stay on their property, and there's no written formal agreement. And then because of that, they toss people off or lock them out or move all their stuff. Well, if you let someone come on your property, they might have an interest in your property. And if you improperly evict them, that could be a problem. Right? And then, sometimes you see it at the end of a tenancy, like the tenancy is done, but the people stay there, and whoever lets them stay there. But then there's the last one, tenancy at sufferance. That means that you've got no right to be there and they don't want you there. Right? So you need to get out. You don't have any right to possess the property anymore. Anybody who has a lease in here, what does it say happens at the end of your lease? Right, you can get into a new lease. You need to let them know that you want to get into the new lease, probably. But if you don't enter into a new lease, then what happens? You need to get out of there, right? Often that's the case. Sometimes it converts to a month-to-month. You know, there are other arrangements. Yeah.
It says tenancy at will for as long as both
Right.
agree. What
That-
if one doesn't agree?
Then it's not at will, right? It's like employment at will, right?
So you can't just throw their stuff out?
Well, yeah, those are two different issues, right? Because that is a common one too. Like, I rented to somebody for a year. I'm using this as an example. I didn't actually. And then after that period of time, it becomes a tenancy at will. They're staying there. They're paying you. You're letting, and then all of a sudden you decide, you know, I want to bring someone else in, or I don't like them anymore. The idea is not to say, oh, they don't have a written lease, therefore I can lock them out, or I can throw all their stuff out on the curb, right? If there is a tenancy at will in that scenario, you want to make sure that you follow the proper eviction process.
It's really hard.
Yeah, well, that's the flip side of it. I would say generally, without getting into all the detail, on this slide it talks about the different laws that apply. Michigan law is pretty heavily slanted toward tenants. Right? So if you're a landlord, it's tough business. It sounds really cool, but it's a tough road. Right?
My mom had a hard time when she had, because my parents own apartment buildings, and they had a tenant that had like a disability or something, and she like kept like flooding the apartments and stuff, like, and it was leaking to the under, and my parents had a really hard time evicting her from the apartment. I brought a dog in there and
Yep.
stuff, and there was no pet
Yep.
release. It was really hard.
Yeah, so even though the tenant might be violating terms of the lease, that doesn't mean that you should. I mean, it's just like us talking about contracts, right? If you think the other party's breaching the contract, what should you do? Tell them to stop. You know, do the things you're supposed to. Because if you breach the contract, if you don't do what you're supposed to do, what are they going to claim? The reason they didn't pay their rent or whatever is because you didn't do what you're supposed to do. So you got to follow the law. Sometimes it is tough. Tenants have a right to possess the property that's described in the lease, use it for the purposes that they've agreed to, maintain it in terms of how they're supposed to maintain it, maybe not common areas, and pay their rent. Just because they don't pay their rent doesn't mean you can automatically throw them out either. I'm going to skip that one. And we talked a little bit about this, eviction, the process of removing a tenant from the property, but it also could be constructive eviction, right? You're letting them stay there, but the premises are so unusable, they might as well not be there. It is, you know, flooded. It is, you know, the doors and windows are missing. There's no heat. There's no whatever. Those might be situations where technically they actually could occupy it, but it's not really livable. And speaking of livable, there's this implied warranty of habitability. This idea, like the implied warranty of merchantability, that if you're going to rent something, it should be livable. Right? And, you know, that obviously that's going to be subject to the court saying whether something is habitable or not. Sometimes that has to do with how you maintain common areas. All right, let's see if there are any more slides that I really want to cover in that one, because there's quite a few of them. Here's one that commonly comes up. If your landlord sells the land, what happens to the lease? Now you have a new landlord. You know, basically, the lease goes with the land, much like we talked about easements going with the land. And then the other issue is whether you, as a tenant, can transfer your interest in the property. And anybody have experience with that? They have something in the lease that addresses whether they can transfer their interest either through assigning the lease or subleasing it. Anybody ever look at their lease to see what it says about that? What's that? Sublease, like a small, so either sublease, like part of your lease, or assigning the lease, the rest of your lease. Often they say you can't do that without notifying them or getting their approval. And, you know, from a landlord's perspective, they go through quite a bit to ensure that they have good tenants. And then if you just try to assign your interest away without them knowing, that can be a problem. All right. Let's jump into environmental law real quick. In environmental law, much like what we were just talking about landlord-tenant law, there's a lot of different law that applies. the common law, which we talked about being case law, state and local regulation, as well as federal regulation. And a lot of this is pretty much common sense in terms of, you can probably guess from the name of the statute. For example, I'll just jump down here to air pollution. The Clean Air Act has to do with what? Clean air. Yeah, that's pretty straightforward, right? So basically talking about stationary and mobile sources, what you put in the air through factories, what you put in the air through cars, and using what I like to call the MACT, which sounds really cool, but basically means the maximum achievable control technology. The best that you can do to limit the amount of pollutants that you put into the air. And there are some pretty serious penalties if you violate these statutes, both civilly and potentially criminally. There's a question on the final exam review sheet that talks about the penalties. If you generally know that there are both civil and criminal penalties for these, you're good to go. You don't have to know specific dollar amounts. Clean Water Act has to do with clean water, right? When I say clean water, everything from what you drink, what you swim in, pretty much any waterway that's navigable, everything short of the ditch or puddle in your backyard. Even wetlands. Anybody live near wetlands? Yeah, there's all kinds of restrictions on those. When I was building our house, we lived right up beside a wetlands, and you couldn't build in there, you couldn't put anything there. They had to maintain it certain ways. There's a lot of restrictions on that. So there's quite a bit of law around what you can discharge into navigable waterways and violations or statutes regarding penalties for violating them. What you drink, what you dump into the ocean. Oil pollution, it seemed like there was a period of time where that wasn't a biggie, but that certainly has been an issue recently in the news in terms of major oil spills. Toxic chemicals, you don't have to memorize all these, the FIFRA Act, a Toxic Substance Control Act, but there are, it's amazing how much issues like this there is even around here in terms of old factories that used to be in existence. They're now out of existence, but there's chemicals that were stored or seeped into the soil, or how do they dispose of it. Here's a big one. This one you will find coming up real soon on the quiz as well as the final exam, and that is CERCLA, which if you read in your chapter what CERCLA stands for, Superfund is much easier and funner to say. Think of a Superfund as this big fund of money that the government has to clean up hazardous waste sites. Right? And in the olden days, if somebody polluted, then the idea was to try to figure out who did it, pursue them, sue them, recover money, and then use the money to fix the problem. The Superfund was created to have this big fund that if something was declared a Superfund site, the government could go in there first, clean it up, and then kind of like shoot and ask questions later, right? And then go figure out who to recover it against. Now, here's the tricky part. It's not too tricky, but they're perps, or potentially responsible parties. If you buy land that later turns out to be contaminated, you are responsible for it even if you didn't contaminate it. So whether we're talking about a home or industrial or commercial areas, you buy property and later it turns out somebody who had the property before you put something in it that's going to damage the environment or damage the health of people around there, then it can be your responsibility because now you own the property. So potentially responsible parties include those who own the land, anybody who bought the hazardous chemicals to the land, anybody who owned the property when they were brought there. So, and notice it says joint and several liability. Anybody got an idea what that means? Joint liability would be you might, among other people, be sued and be responsible for cleaning up the site. But several means they might go after you only. So think about this. You buy land, and then you find there's some hazardous chemical on it. And the government comes looking for whoever did it and can't find anybody. Or the party that put it there is bankrupt and out of existence, or is hiding or whatever. Who are they going to go after? You. So what do you want to make sure you do when you buy land? Make sure there's nothing on it, right? And if there is, you either don't buy it or you make sure it's cleaned up before you get it.
I
Yeah.
heard about that happening with this hardware store owner.
Yeah.
Who bought the hardware store from a previous hardware store owner. And it turns out that previously had been burying paint and chemical stuff in the
Yes.
backyard, basically.
Yes.
And then he died off. And then
Right.
another guy bought it, and then he died.
Probably from the chemicals in the ground, right? Yeah, and don't ever buy property and think, oh, I trust whoever it was, because it may not be them. It might be, a long history of things that people don't know about. Being from Hastings, anybody know the Hastings area? There's M37 and 43 connect in Hastings. And right there's this gas station. Basically, it's set for most of my life, which is, like a long time, empty, because it used to be a gas station, and it closed down because the tanks were seeping into the soil, and then the whoever owned the gas station, they're going long out of existence. So here it set this property contaminated. Nobody wanted to buy it to clean it up, and people just looking for somebody to hold responsible for it.
There's one like that over in Plainfield too. It's like a really old four-star gas station that really wants just that.
Yeah, the MTech, one of our campuses. Anybody the downtown Grand Rapids MTech Center? What's around?